We'll begin with the first case on the docket, which is Pagan versus State.
My name is Joseph Fisher. I'm on TOMAS Lottery.
Approach the lectern and proceed. If you want to reserve any time for rebuttal, let me know what that is, and I'll help you watch the clock.
I'd like to reserve 2 minutes for rebuttal.
Okay.
The first issue I want to address is the blood analysis that was admitted at trial that was performed at the request of law enforcement under the implied consent law. It shouldn't have been admitted because the collection, storage, and testing that go into the rules are inadequate. This was an issue that was addressed in 2000 by the Supreme Court in Miles versus State. The court took this up that anticoagulants had to be added to the test tubes that are carried by law enforcement when an FDLE blood draw is given. The problem is, after Miles, the rules are still deficient on the issues of, one, the rule does not prescribe the amounts of preservative anticoagulant that are required, and it doesn't mandate the use of a particular type. Any kind of anticoagulant can be used. It doesn't mandate which kind. There's several different kinds, hundreds actually. An expert testified prior to trial and pre-trial motions that any kinds can be used that aren't typically used for forensic purposes. Also, another issue that was never addressed when they went back and modified the rules after Miles was the storage of the kits. Commonly, these kits are stored in the trunks of police cruisers. They drive around for months with these things in there. It's hot outside, obviously. We're in Florida. How hot does it get inside the back of a police cruiser? What does this do to the integrity of the kit? These are issues that were never addressed or never corrected. These are simple things that can be changed, specifically the amount of the anticoagulant, which affects the metabolic process of blood, and the amount of bacteria or fungus can either increase or decrease the ethyl alcohol. This goes to an essential element of, how much was the BAL from the blood draw? The integrity of the rules is vital in a case like this.
Was the testimony that the existence of any of this bacteria would actually result in a lower blood alcohol level? So if there was any, it would be favorable to the defendant?
It could go, they don't know. They could say it could go higher, it could go lower.
Well, what was the testimony by the experts?
It could be either way. It could be higher or lower. And what should have happened in this case is the court should have gone back and used the traditional predicate that the state would have had to gone into the three-pronged test that was laid out in Robertson, which is, one, show the test was reliable, two, show the test was performed by a qualified operator with proper equipment, and three, the meaning of the test, put on an expert witness. And the implied consent should never have been instructed to the jury as to if the blood alcohol was found to be above a certain level, then there's grounds that the client was intoxicated in this case. The jury never should have heard that, and that should not have been allowed. The state should have had to have gotten this into a traditional test, set up the predicate. The next issue I want to address is the issue of the autopsy report. And the biggest problem with the autopsy report, it was brought into trial by a doctor who did not perform the autopsy. And what really concerns me is not so much the Crawford analysis. I get into that, but I don't want the court to be distracted by that, is the fact that the state never laid a proper foundation to get it admitted as a business record. The doctor in this case never testified.
What harm did that do? I mean, given the nature of this case, I mean, there was no dispute that there was a death, was there?
There was no dispute as to the identity of the victim. There was a dispute as to the cause of the death. And a doctor testified that the victim in this case died from blunt force trauma on impact. And that is an essential element in DUI manslaughter, is to the manner and the means, how was the victim killed? That's an essential element.
Was the autopsy report the only evidence that was put in as to the cause of death?
Yes.
It was?
I believe so. And when you go into...
Wasn't there testimony that she screamed immediately before the accident and that she was declared dead at the scene immediately thereafter?
I believe there was testimony she was declared dead at the scene, but the issue is, how did she die? And I mean, that still goes.
Well, you have an accident, a person that was alive before the accident occurs and the person dies. So was that a substantial issue in the case?
I think it's a substantial issue in the case because it still goes to an essential element, and it's hearsay. The record is hearsay, and it can come in if it's established as a business record, and it was not done. And I don't think it's a harmless error in this case. And I think that the state should have elicited that the report was made or transmitted from an individual with personal knowledge. And if you look at the testimony of the doctor that testified, she's very evasive as to whether the report was made at or near the time of the autopsy. She really doesn't know, and it's allowed in. And then another issue that's very troubling.
Is there any other evidence in the record as to how this person died? I mean, that's it, just the autopsy report that it was caused by the...
and other than the fact that there was a car accident, there was a construction scene, cars trying to merge over into what could be a race. There was testimony that there were signs down directing which way the cars were to go. Another issue that's also, again, the court did this not once but twice in the medical blood analysis that was allowed in. Also came in even though it was never established to be a business record. There were strenuous objections made on the record, and again, you see the same thing. The court allows it in. The foundation wasn't there. It wasn't met. And again, assuming for argument's sake that the medical blood in this case was established as a business record, there's still problems with that and the fact that there was uncontroverted expert testimony that medical blood and legal blood, the difference is night and day. You look at medical blood, it's for diagnostic purposes only. They do a quick turnaround when they test it. They don't use the same procedures, and the reason for that is in a medical setting, they just want to know, is there anything in the blood? What's in there? They don't want to know the exact amount. The storage and handling is totally different in this case. Night and day, blood serum in medical blood is analyzed. That's the liquid portion after it's clotted, and experts in this case testified that it has a 15 to anywhere to a 59% higher concentration of ethyl alcohol. Medical tests are trustworthy for medical purposes, not for legal purposes. And again, this test was admitted even though the person who allowed this in, there was no proper predicate for this test to come in as a business record under the hearsay exception. And this is very troubling. And I think it could have been easily done to qualify as a business record. The records custodian just never testified that the records were made by or from a person with knowledge, nor did she testify that the records were made at or near the time of the event recorded. And again, this is the second time the court, in this case, failed to establish a sufficient predicate for admission of the evidence as a business record. And I don't think it's harmless in this case because I think, you're looking at evidence concerning analysis of both legal and medical blood draw. And the jury is hearing both of this. And, who's to say what exactly they're basing their decision on, but you have bolstering because they're hearing the medical blood results and the legal blood results. And the evidence of the blood analysis conducted at the hospital, it tends to bolster the blood test and vice versa. And I think the autopsy report coming in, even though no proper predicate was laid, the cause of death is established. It's an essential element of the crime. They didn't get it in properly. It shouldn't have been in. And I think it's not a harmless error in this case. And
did the jury hear evidence or testimony explaining the difference between a medical draw and a blood draw for purposes of establishing whether a person's driving under the influence? The jury never heard any of that?
This was all pretrial motions. The expert, Dr. Masson, in this case, testified.
Okay, so there was no cross-examination or
it was objected to, but there was no cross-examination of the expert at the trial. It was all right before the trial.
But did the jury hear evidence from either expert that a medical draw will usually have a certain percentage higher result than a non-medical draw?
No, they didn't. And the state didn't offer an expert in pretrial motions. It was only the defense that put on an expert in this case.
Well, was there anything that prevented you from, you said you put on some testimony or an expert, was there anything that prevented you from eliciting that difference and presenting it to the jury and arguing to them, well, this is reliable, but this isn't?
I don't know. I wasn't the counsel at trial at the time. I don't know if there was or was not, but I'm just going based on what the records show. And there wasn't, I don't know. I know the judge ruled on it, and he made his decision and said that he was admitting both the medical blood draw and the legal blood draw. And again, going back to the implied consent, the jury was instructed on implied consent, and I think there's a really strong issue here with regards to the fact that these rules do not call how much anticoagulant should be in these test tubes. How should they be stored? The swabs, when the drivers are swabbed before the blood is handled, the expert gave uncontroversial testimony that in the antiseptic, it's impossible to find an antiseptic swab that's free of alcohol. What would be proper in this case is to have what is the level of alcohol that would be acceptable. That's the scientific standard that was testified to, and that's easy. All they have to do is get a certificate of analysis from the manufacturer stating, look, there's no more than, blank percentage of alcohol in this case. That's not done. This can affect these tests. These are simple things. The amount of anticoagulant, the percentage of alcohol in the swab. These are things that should have been changed after Miles, and the Supreme Court in Miles addressed the issue of, hey, look, they need anticoagulant. It might be universally known in the medical community, but we need an amount. How much? And that it needs to be in the tube. We've got it in the tube now. Then the question is, we don't know how much or what kind. How much is too much? How much isn't enough? These are all things that affect the metabolic process of the blood, and experts will testify that all day long. The question is how come certain parts of the rules were amended after 2000 in Miles, but these other issues are still out there lingering when this is a hot-button issue, and I think this could be changed. And again, if you look at all the issues in this case, starting with the legal blood draw, and then the autopsy report that was admitted by a doctor who didn't perform the autopsy, who didn't even testify to the credentials of the doctor that performed the autopsy.
I'm still having some difficulty trying to understand how admission of the autopsy report justifies reversal in this case when it appears to me, correct me if I'm wrong, it appears from what I read in the record that this was an incident where two cars may have been racing, and the car that the passenger was in hit a concrete wall or whatever, flipped over, and then the decedent was ejected from the car and was found dead at the scene. Is that basically what happened?
That's essentially what happened, Your Honor, more or less.
And so the autopsy report comes into evidence and says she was killed as a result of the accident, but that's that's a harmful admission that affected the jury's decision in this case.
Yeah, I think it's powerful testimony when a doctor gets on there and tells the jury, look, she was killed.
She was killed as a result of the accident.
By a result of the accident.
I mean, was there any dispute that the decedent was ejected from the car and was found dead at the scene, but was alive before?
No, there was no dispute that she was ejected from the car. Okay. And again, I think the key issue in this case is the legal blood draw and the requirement.
That's your strong issue here.
And I think it's something that it was partially addressed after the Miles decision, and I think there's still issues with it. Really, really big issues in this case.
Counsel, you're down to a minute.
And I also think the medical blood tests should not have been heard in this case. And I don't think that's harmless, because it's bolstering. I mean, the jury's hearing again that, well, the hospital has a blood draw in this case, and there's expert testimony that in storage and handling procedures of the blood at the hospital, there isn't an anticoagulant used. It's a quick turnaround. The storage procedures aren't the same, whether or not it's refrigerated or what happens to the blood after that. That's why the rules are patently different from a legal blood draw and a medical blood draw. And I don't think that should have come in either, especially given that it wasn't established as a business record underneath the exception to hearsay. I think there's rules that should have been followed, the court didn't follow them, and there's reasons for these rules. And if you parse these issues down, there's enough in this case where I think there mandates a reversal.
Okay, counsel, you've exhausted your time. Thank you.
May it please the court, my name is Ann Phillips. I'm here on behalf of the state of Florida. It's the state's position that the evidence in this case is properly admitted and reversal is not warranted. The administrative rules were not proven to be inadequate. Mr. Pagan's argument would go to the weight of the admissibility of that, not the admissibility. It would go to the weight of the evidence that was given. He chose not to put on any evidence at trial. This was all done pre-trial. The fact that rules could be different and could be more complete or could have additional stuff does not make them inadequate. Here, this case is different than Miles because the rules were completely lacking in the refrigeration requirements and things like that. Those have been addressed. The defendant's expert has not shown the rules as they exist now to be inadequate. The state would say it goes to the again to the weight of the evidence, not its admissibility.
Did Miles address the issue of the anti-flagellants?
Not in the manner that he is talking about. They did say that anticoagulants are necessary. The rules now say that an anticoagulant shall be used. It does not state an amount, but there was nothing in Miles that showed that that part needed to be in the rules. So I would say that the rules certainly are in compliance with Miles at this point, and there hasn't been shown to be an inadequacy here.
Do the rules provide that if there's any clotting that it's an invalid result?
No, it states it provides the that it should be in there and that it shall be, and it provides the name of one that can be used, or it says other ones are also appropriate.
Well, isn't the purpose of the anticoagulant to prevent clotting because of the fear that if the blood is clotted, you may not get a valid result? Correct. Okay, so is there anything in the rules that says if it's clotted, don't use it? If there's any sign of clotting?
I believe there is, but I cannot be certain as to that. Additionally, we would say that any error in this would be harmless based upon the evidence in this case. Likewise, the admission of the autopsy report, the testimony causing the death, we find that there's no error there, and worse, any error would be harmless. The victim was alive when she got into the car. The car was involved in an accident. She was ejected from it, and she's dead. They stipulated to that. I believe the jury can, on its own, draw a conclusion from that the cause of her death was being involved in the accident. The blood analysis by the hospital was properly admitted as a business record. Again, any problems with that he would have would go to the weight of the evidence, not its admissibility. We believe the evidence in this case is clear and his conviction should be upheld. If there's no other questions, the state will rely on its brief and ask to be affirmed.
Thank you, counsel. Memorial